Professor Fineman's work has moved on a steady trajectory from a critique of autonomy as a founding myth in American political and legal life into a broader focus on the legal implications of universal dependency, vulnerability, and justice. Her recent work formulates a theory of vulnerability in order to argue for a more responsive state and a more egalitarian society. She's founded the Vulnerability and Human Condition Initiative at Emory Law School in 2008. She's also an affiliated scholar of the Center for American Progress. Her lectures at Smith College introduce and expand upon this theory of vulnerability and the human condition. In her 2004 book, The Autonomy Myth, Professor Fineman argued that popular ideology in the United States has become fixated on the myth that citizens are and should be autonomous, yet dependency is unavoidable in any society, no less in the United States than in any other nation. In her 2011 article expanding on the concept, Fineman explains that vulnerability is and should be understood to be universal and constant, inherent in the human condition. The vulnerability approach is an alternative to traditional equal protection analysis, representing a post-identity inquiry in that it's not focused only on discrimination against defined groups, but concerned with the privilege and favor conferred on limited segments of the population by the state and broader society through their institutions. Two scholars commenting on her work recently noted that in moving beyond gender and other identity categories, Fineman uses the concept of vulnerability to define the very meaning of what it means to be human. Professor Fineman is the recipient of numerous scholarly awards, including the 2008 Cook Award from the School of Industrial and Labor Relations at Cornell University, and the 2006-2007 Leverhulme Visiting Professor at one of the United Kingdom's top academic honors. She's also a recipient of the prestigious Harry Calvin Prize awarded by the Law and Society Association to a scholar whose body of empirical scholarship has contributed most effectively to the advancement of research in law and society. She's also been awarded an honorary degree, among others, by Lund University, where she has held the Hedda Anderson Visiting Professorship since 2012. Recently, she's been appointed part-time to the law faculty at Leeds University, which is creating a center for the study of vulnerability in connection with other universities in Europe. Her lecture today, Vulnerability and Social Justice, includes a critique of equal protection analysis that I just mentioned. And I also want to mention that this idea of vulnerability is actually can encompass a very broad scope of things. In addition to the Neilson lectures, on April 8th and 9th, Professor Fineman is conducting a workshop here that will be on vulnerability and the environment. And we should have a really interesting group of scholars, including several scholars here at Smith, talking about vulnerability, resilience, and social justice in the environmental sphere. So please welcome me, join me in welcoming her. Thank you.
Well, thank you very much for that introduction, and thank you to Smith for having me here as a Neilson professor. I'm really enjoying my time here, and hope actually I get to meet many of you in person after this lecture. Vulnerability and social justice. Social justice is a phrase in use today, and it has an interesting history. According to a 2000...
You're taller than I am.
According to a 2006 report by the United Nations Department of Economic and Social Affairs, unlike justice in its broadest sense, social justice is a relatively recent concept. It arose with the struggle surrounding the Industrial Revolution and the advent of socialist, social democratic, and Christian democratic thought. Social justice addresses what was considered to be the necessary organization of a just society. The age of industrialization was an era of tremendous economic and social and political dislocation and transformation. Social justice was used as a rallying cry by progressive thinkers and activists who understood it to be a call for the fair and compassionate distribution of the fruits of economic growth. And this was true particularly for the working class. Some of their ideas were eventually implemented through progressive income tax, antitrust regulation, and workplace regulations. Their concerns with the distribution of wealth and income and providing adequate public services also propelled reforms regarding education and employment. Important to the reformers' philosophy was the principle that social justice was to be accomplished by social means. An active and progressive state and its institutions were to be given the authority to pursue the common good. And in this pursuit of the common good, public agencies were to develop robust and coherent policies of redistribution. Franklin Delano Roosevelt's Second Bill of Rights, which evolved in 1944, was a social justice document. In it, he outlined a vision of social citizenship, a fair deal, in which the governmental authority would be deployed to ensure that everyone would be guaranteed the protection from the harshness of the market as a matter of right. Among the specific rights enumerated were the rights to work and to decent pay, the right for every family to have a decent home, the right to adequate medical care, the right to protection from the economic disasters arising from sickness, accidents, and the security and unemployment in old age or resulting from economic dislocations. These ideas were realized, of course, only partially, and too partially perhaps, in the United States, but the basic principle that government should intervene to provide some level of economic and social protection in the face of inequality did become institutionalized during that era. This recognition of an active role for the government was broadly accepted until the 1970s. It no longer is. Today, we again face widespread inequality and the consolidation of wealth and power. The UN report concluded that there was little hope that a collective approach to social justice implemented by a progressive state was viable in today's world, however. The meaning of terms changes over time and in relation to economic and social and political circumstances. And the report suggested over time the term social justice has lost most of its social focus. The report specifically addressed the effects of one influence, a progressive but individually focused human rights agenda, an agenda that stresses formal equality and anti-discrimination as state policies and emphasizes individual liberty, dignity, and choice. Justice is now to be found in the protection of the individual, not the creation of public good. And to the extent that individual dignity and liberty are constructed as barriers against state action, because state action might interfere with individual choices or autonomy, individual rights complicate the idea that the state can undertake efforts to effect something called social or collective justice. Another 20th century doctrine, neoliberalism, is perceived to be on the opposite pole of the political spectrum from human rights. But it also has propelled the shift to an individual rather than a collective conception of justice. Neoliberalism grew out of classic liberalism, but it departs from it in one very significant way, the role envisioned for the state. Neoliberalism has been defined as a political economic theory based on the principle that freedom, justice, and societal well-being are best guaranteed by a system that protects private property and promotes open markets and free trade. Unlike classic liberalism, however, neoliberalism is not a system where the state is restrained. Rather, the state is reoriented to serve the market and to privilege capital. It is a radical theory, not a conservative one, although it's often labeled conservative. It's a radical theory in which the market becomes the key mechanism for ordering society and distributing its benefits and burdens. And in performing this task, the market must be protected and empowered by the state. In the words of Milton Friedman, perhaps its most influential proponent, neoliberalism proposes that it is competition that will lead the way, I assume that's to paradise. And he concludes the state will police the system. It, the state, will establish the conditions favorable to competition. This is a market-driven, not a socially driven notion of justice. In the words of another of neoliberalism's ideological architects, Friedrich Hayek, the word social is redundant. Justice is what a free society produces, here through the market and competition, of course. He also said that the greatest service he would render, and his scholarship could render, was to make people thoroughly ashamed to employ the term social justice. He was not successful in banishing the term, but perhaps he would not object to the way that social justice is currently understood, which I suggest is mostly in ways that are consistent with neoliberal objectives. It seems that over the course of the 20th century, justice has generally increasingly been understood in terms of the relationship between the individual and the economy. And it is this relationship that increasingly defines the role of the state. Left-leaning philosopher Philippe Van Harris, who was actually a staunch proponent of a basic income guarantee, recently explained his vision of contemporary social justice. Any defensible conception of social justice today must articulate the importance we attach to equality, freedom, and efficiency. Efficiency is the economist's term, of course. He continued, social justice must be liberal and egalitarian. Liberal in the philosophical sense of professing equal respect for the diversity of the conceptions of the good life present in pluralistic societies. So much for a collectively defined and realized vision of the good life, and this was quickly, of course, dismissed by his comment, today we are not starting from the pre-modern conceptions of justice, which begin with a specific notion of the good life. And egalitarian, in his interpretation, is not to be interpreted to mean equality of outcome, whether that is measured in happiness, income, wealth, health, or power. Rather, he identified two ways of justifying inequalities in distribution, two ways of understanding how inequality can be, in fact, just and do not violate a mandate for egalitarianism. The first was the idea of personal responsibility. If individual opportunity is to be equalized, then so too should be individual responsibility for outcome. The second justification for inequality is efficiency. And again, this is a favorite of economists. It would be unjust and inefficient to equalize society at all costs. Equality should be the sustainable maximization of the real freedom of those with the least freedom. There's two terms, I think, of interest here. One is real as modifying freedom, and sustainable as modifying equality. In that statement, I hear echoes of the current political debates about welfare dependency and moral hazard, as well as those that highlight the plight of the poor taxpayer. The perspective on social justice boils down to two propositions, and remember, this is a progressive perspective. First, a society's responsibility is to ensure sufficient opportunities for individuals to engage in productive economic activities of their own choice. Social justice maximizes individual choice and liberty. Second, personal and social rewards are justly distributed when that distribution is commensurate with individual talent, initiative, and effort. Outcome is based on a meritocracy or assumption of meritocracy and individual responsibility. In addition, taking advantage of offered opportunities is seen as providing even more freedom. And here, significantly, these additional freedoms are identified as the freedom to consume. We've become consumers instead of citizens, as well as the freedom to determine what one does with one's life, to maximize economic potential and social position as one individually defines them. This so-called progressive conception of social justice is rooted in the economic and built around the individual. It is social justice as individual economic justice. The state is not responsible for the provision of goods and services, except perhaps as a minimal kind of safety net, but it is responsible for ensuring economic and employment opportunities for individuals, not the employment itself, the opportunity. The only laws necessary for this vision of justice are those that prohibit discrimination, complemented by guarantees of political and civil rights recognizing individual dignity and autonomy, and moral arguments for policies aimed at redistribution based on broader conceptions of justice can be easily disposed of by reference to some notion of moral relativism or cultural pluralism or taxpayer fatigue. It seems in this age of inequality, which incidentally is as pronounced as that which preceded or produced the concept of social justice initially, we have all, at least to some extent, become disciples of Ronald Reagan and Margaret Thatcher. So, pressing question, is it possible to bring the social and distributional dimensions back to our perception of social justice? Oops. Help. Something happened. I can't, it doesn't do anything. You'll see I really need the slide. Oh, there it is. Okay, great, thank you. All right, so my answer to this question, is it possible to bring the social and distributional dimensions back to our perception of social justice, is perhaps if we can effectively challenge and undermine the individuality and autonomy that lies at the center of neoliberalism. And in this endeavor, the language of dependency, vulnerability, and resilience can be of assistance. And this slide, the autonomous liberal legal subject, is the Brooks Brothers version of the figure at the center of neoliberal demands for individual liberty and personal responsibility. This is what they envision. In explaining the vulnerability approach, I begin by posing two basic questions that should be part of any discussion of justice. First, what does it mean to be human? Is there an inherent or universally shared characteristic, situation, or circumstance comprising the human condition? So what does it mean to be human? This is a foundational question, how we understand the legal or the political subject. Is this our legal or political subject, Mr. Brooks Brothers suit? Second, given our answer to the first question, what is the appropriate allocation of responsibility for individual and societal well-being across the individual, the state, and its social institutions? This is the question of justice. What are the terms and values of our social compact or contract? My answer to the first question is that human beings are embodied beings and therefore inherently vulnerable and susceptible to change, both positive and negative, in that embodiment. So we are first embodied creatures. In addition, and partly in response to our embodiment, we are inescapably embedded in social and institutional relationships that are structured in society through both law and culture. Social arrangements are, of course, also susceptible to change, so we see that the human condition is one of inherent impermanence in both its physical, embodied, and social embedded manifestations. Having resolved this first issue, at least for myself, answering the second question about the allocation of responsibility has been my ongoing project within the Vulnerability and Human Condition Initiative that I began at Emory in 2008. A key concept in a vulnerability approach to social justice is, of course, vulnerability. Often narrowly understood as merely an openness to physical or emotional harm, vulnerability should be recognized as the primal human condition, universal, constant, and continuous over the life course. And a vulnerable subject must replace the currently dominant notion of an autonomous, liberal, legal, political subject. Recall that vulnerability has two dimensions. Humans are embodied beings, and the top slide reflects the difference in embodiment or developmental stages across the life cycle. And two, we are also embedded in social relationships and institutions. And the bottom slide reflects the fact that we occupy different social roles across our lifetime. Unlike the abstracted and static adult liberal subject, this is a dynamic understanding of what it means to be human. Importantly, as an embodied being, the vulnerable subject is a doubly dynamic concept, reflecting in the first instance the variations in embodiment among or between individuals. And we call this horizontal notion of difference here. This is the horizontal variations. But the idea of a vulnerable subject also focuses our attention on the life course and the fact that there are variations in the embodiment of each individual over their lifetime. And I refer to this as the vertical aspects of difference. Changes in individual embodiment is an inevitable and natural part of the human condition. Understanding both types of variation in human embodiment should have implications for defining the ideal relationship between the state and the individual. In other words, this understanding of the human being should affect what we think of state responsibility. It should affect how we understand what is a realistic and just social contract for how we achieve social justice. In fact, the first form of variation, this horizontal differences among individuals, has already altered our perception of state responsibility over the course of the 20th century. Anti-discrimination and equal treatment principles have made progress in including individuals located across various categories of differences based on variations in race, gender, and ability, for example. About the same attention and consideration of what is an appropriate state response has not happened when it comes to the vertical variations in embodiment, the differences that naturally occur for every individual over the course of his or her life. So adults of different races, genders, and abilities are afforded full protections from discrimination by the state, but children and others who are marked as dependent and not capable of acting autonomously are defined as constituting discrete and inferior groups within society. They're given a separate, qualified, or special legal subjectivity, significantly focusing only on an adult and therefore incomplete and static version of what it means to be human, obscures the constancy and inevitability of human dependency. Now, dependency is a complex term, although it's not often treated that way. One form of human dependency is universal. We all experience it, and I label this inevitable dependency. Each human being experiences a range of developmental stages, some of which result in our dependence on others for care. The situation of the infant or the child is exemplary here. Why that form of dependency may lessen or change as we reach physical maturity, many, if not most of us, will also be dependent on care from others when we are elderly or become ill or experience impairment. But, and perhaps most important, there is a second form of dependency, one that is not, in fact, universal. And the concept of derivative dependency captures the simple but often overlooked fact that caretakers, those who care for inevitable dependents, are themselves dependent on resources in order to successfully effect that care. And the derivative dependency of caretakers, however, is not universally experienced. That dependency is structured through ideology, aspirations, and expectations to be the responsibility of only some individuals and some institutions. In the United States, the family is the way that we privatize dependency. And we typically feel there is no public responsibility for the burdens this places on those within the family who assume the role of caretaker. Contract, individual freedom, choice, arguments that there is a basic collective or social responsibility for dependency beyond the private family are typically dismissed or ignored, and autonomy and contract are the dominant metaphor. Caretaking is not a social problem, it's an individual choice. Caretakers are, after all, free and autonomous beings. So the mantra of liberty, autonomy, agency, consent, choice assign risks and responsibilities for certain social positions to individuals rather than to the collective. While we might call caretaking an individual choice, it is also a social role that is essential to society. It's what produces the next generation, for example. And it's hardly a free choice. The assumption of caretaking is shaped and limited by both individual and social circumstances. In a vulnerability approach, caretaking is seen as part of a developmental stage in the life course of an embodied vulnerable subject, not the product of an autonomous one. A stage reflecting the emotional and or reproductive possibilities of our embodiment. Along with other experiences, caretaking is the natural expression of the need for intimacy and connection that all human beings share. Undertaking care is one way that we respond to the physical and emotional needs inherent over our life course. And understanding care work decidedly should not be seen to create a separate legal subjectivity for the caretaker, and certainly not one that absolves the state of responsibility for either inevitable or derivative dependency. Now, my working through this caretaking dilemma was important to crafting a vulnerability approach. The insight that came that I realized some forms of dependency are in fact derivative, this idea of derivative dependency. Some roles mandate reliance on resources and institutions, can in fact be applied to most aspects and undertakings in life. And as embodied beings, we are inevitably and inescapably caught up in social relationships and institutions throughout our life course. The dependence of the caretaker, the derivative dependence of the caretaker, is exemplary, not merely derivative. It illustrates the necessity of relationships and structures, one structure of institutions, upon which we rely in all aspects of our life. And because of their role in human lives, we must interrogate the nature and functioning of the institutions that make up the ecology of a society. This includes those financial and other institutions that are classified typically as private, and for this reason not thought to have structural or primary responsibility for dependency. These institutions are key in understanding the social dimensions of human vulnerability and the ways in which we are embedded in and dependent upon webs of relationships and institutional arrangements. This last assertion brings me to the concept of resilience. And resilience is extremely important in a vulnerability analysis. So though we begin with vulnerability, where we want to end up is with the idea of resilience and state responsibility. Properly understood, vulnerability as arising from embodiment and located within social context should make it clear that there is no position of invulnerability. No position. No one is invulnerable. Fortunately, there is resilience. Resilience is found in the material, cultural, social, ecological, and existential resources that allow us to respond to our shared, constant, universal vulnerability. Resilience is measured in part by an individual's ability to survive or recover from harm or setbacks that inevitably occur over the life course. But resilience has positive manifestations also, and it's really important to realize this. Resilient individuals can form relationships. They can undertake transactions. They can take advantage of opportunities or take risks in life, confident that if they fail or there are challenges, unexpected obstacles, they are likely to have the means and the ability to meet them and to recover. In other words, resilience allows us to respond to life, not only to survive, but to thrive within the circumstances in which we find ourselves. And significantly, human beings are not born resilient. Rather, resilience is produced over time and within social structures and under societal conditions over which individuals may have little or no control. Now, we know that resilience is not distributed equally across society. And while sometimes a lack of resilience can be deemed an individual failing, often it is a function of unequal access to certain societal structures. But this is not only a question of access, it also is true that within institutions, even if you have access to them, there are quite often unequal allocations of privilege and power within those structures. Too often, we take those who are deemed failing without sufficient resilience and segregate them according to some characteristic or another, such as poverty, illness, age, and we blame them or those characteristics more accurately for their situation, for their circumstances. They're seen as deficiencies. These individuals are classified as more vulnerable to harm and disadvantage than are the rest of us. Herding some individuals into populations defined as differently or particularly vulnerable, as vulnerable populations in fact, and therefore somehow inadequate, stigmatizes the individuals within those groups. And this is so if the purpose of the designation of a vulnerable population is to protect, as it is with children and the elderly, for example, or to punish or control, as it is with those who are identified as at-risk youth or single mothers, it's a big term. So it stigmatizes, whether it's protect or punish, in both instances the individuals are stigmatized as somehow or another deficient because of a characteristic. Worse, however, than even that, I think, is that the idea that there are discrete vulnerable populations gives the impression that somehow or another the rest of us, those who stand outside of those populations, are not, in fact, vulnerable. We are invulnerable. Once again, that's impossible. We are all vulnerable, universal, constant, across the life course. The basis, or the appropriate basis for distinguishing some of us from better positioned but equally vulnerable subjects should be the lack of sufficient resources, the lack of resilience needed to address a shared common vulnerability. Importantly, the emphasis here, if we look at it this way, is not on the lack, it is on the lack of resources, and the question presented is whether institutions, not individuals, are performing inadequately. This inquiry recognizes that often a deficit in resilience reflects an institutional or societal failing more than an individual failing. The fact that a vulnerability analysis brings the life course into the focus is also important in this regard. Note, resilience conferring institutions operate both simultaneously and sequentially in society. You can see that in these institutions. That they are sequential is significant because it illuminates how failures to succeed and to gain resources or resilience in one stage of life can fundamentally affect the ability of an individual to succeed in another. So an inadequate education will impair the ability to secure employment and accumulate material goods, which will also affect things further down the line, like health, family formation, and their prospects in old age. Movement into a new phase depends on successful accomplishment of the tasks set in the earlier stage, and it may be difficult to recover if this in fact doesn't happen. The fact that institutions operate simultaneously is also significant when we think about resilience. So resilience gained through one institution or relational arrangement can often offset or mitigate disadvantages experienced in others, or vice versa. A strong family can compensate for a weak education. Violent or abusive family, on the other hand, undermines even the advantages of a strong education. Final point. Resilience must be tied to a well-developed notion of state responsibility. This partial list of incomplete resources of resilience are actually produced by a variety of institutions in society, labeled both public and private. Many of these resilience-conferring institutions are also perceived in contemporary political rhetoric to be separate from and independent of the state. And this is particularly true of market institutions and family institutions. The state is mandated under various dominant ideologies: free market, small government, individual liberty, family privacy, and/or efficiency, to be restrained, not to intervene or interfere with the innovations of the market or the magic of the family. So one task for a social justice scholar is to show the myriad ways in which the state actually creates, maintains, supports, and subsidizes these institutions, public and private, through its laws and policies. And it's important here for us to look at tax, corporate, and finance, as well as family and poverty laws. The task is to reveal the conferral of social subsidies and privilege to and through these institutions. Further, the argument must be that considering the significance of these institutions to individual and societal well-being, it is imperative that they be effectively monitored and regulated. The direct link between institutional action and the possibility of societal harm should create an institutional social responsibility as the basis for state regulation. We must recognize that as human creations, institutions, all of our institutions, are also vulnerable, although differently so than human beings. Institutions act inequitably, are vulnerable to capture, corruption, decay, and failure, and these vulnerabilities have implications for society and for state responsibility. And we must be clear that the state responsibility for institutions goes well beyond merely identifying and ferreting out impermissible discrimination in access or operation against select groups. It goes beyond enacting equal protection and anti-discrimination laws, which really only mandate equality in opportunity and treatment. State responsibility must also encompass the broader, more inclusive obligation to give equal regard to be equally concerned with the complete range of capabilities and dependencies that can and do occur across the human life course of all individuals, and to be attentive to the role of these institutions in building resilience, to ensure that they do so in a way that is just and fair. There's a remaining question, of course. How would this state responsibility be defined and implemented under a vulnerability analysis? And this is actually going to be the subject of my last lecture, so maybe the test should come. But the big question, and what most important, basically and briefly, is a responsive state would recognize this need for diligence in monitoring the functioning and structure of its institutions, private as well as public, and perhaps particularly private. And it would ensure that laws regarding those institutions are sensitive to the fact that they confer privilege and disadvantage to individuals. But to sum up today's lecture, the prototype of the legal subject as an autonomous and independent being whose primary demand is for liberty and freedom from an essentially threatening, potentially interventionist state has to be confronted and contested. I believe the concept of the vulnerable legal subject has the power to disrupt the logic of individual choice and personal responsibility that's built on this neoliberal stereotype. It does so by articulating a more inclusive and realistic legal subject, one that makes it clear that there is an injury or injustice inevitably arising from a state unresponsive to vulnerability and dependency. It does so by imagining the responsive state as an instrument of social justice. So I want to leave you with two competing images. One is the projection of the responsive state. This is the utopian version. The other is the image of a rogue and in need of restraint state, the dystopian vision. And I also want to leave you with my argument that the state, in some form, is necessary, because laws are necessary, and because we don't want either international corporations or a Hobbesian anarchy to form the rules and values that shape our society. Law is the recognition that all human endeavors are social endeavors. As such, they require enforceable rules, set out concurrent duties and responsibilities to guide living and working together harmoniously and productively. There can be no neutral or inactive state. Once we realize that over history, humans have joined together in families and in communities, created public and private institutions, political and corporate entities, the nation state, as well as international organizations in response to our shared human vulnerability, it seems obvious that those institutions and the laws that govern them should be responsive to that vulnerability. To me, this would indeed be social justice. Thank you.
So I really like the idea of individualized, embodied being, and conceptual vulnerability. It has a lot of synergies, it seems, with kind of an intersectional approach to understanding people's place in society. But I wonder about this word stigmatizing when applied to identity groups and their vulnerability that might be assigned to members of a certain group, as opposed to their embodied being. Because it seems like, especially in the current society, there are many groups that have kind of systematic vulnerabilities based on some of those categories that we discussed, whether physical, even social, ecological rights, essentially. And so there might be remedies that are appropriate for targeting those vulnerabilities for groups that are distinct from those of their individual identity.
Okay. There's a lot to unpack. Yeah. I'm asking you to think about things very differently than you do currently. So, for example, when you talk about the intersectional approach, when I look at intersectionality, I do not look at intersections of things like race and gender. I look at the intersection of social roles. So it's not your identity as a woman, for example, that's really relevant in the vulnerability analysis, but rather your identity as an employee rather than an employer, as a caretaker, as a parent rather than a child. These social identities are all controlled and given content and effect by law. So it's those identities that, in fact, I think the state, the responsive state, really has to look at and assess the conferral of privilege or disadvantage in those relationships. And I am going to talk about that quite a bit more in the next discussion. As far as the traditional identity categories, which is what I think you're referring to, they are, in fact, addressed in law already through anti-discrimination and equality provisions. And that is the differences in embodiment. I'm not as interested in the differences in embodiment, those that lead to legislation addressing discrimination, as I am in this notion of differences in our embedded nature, the differences that are produced within these institutions, these differences that distinguish between parent and child, between teacher and student, between employer and employee. Those are not the traditional notions of identity, but different. These are the socially produced conferrals of privileges and disadvantages within these social institutions and relationships. So that's really what my focus is. So we have discrimination over here. That's a supplement. But I argue discrimination, in fact, doesn't go far enough. Discrimination, after all, leaves in place the fundamental structures of a society. All it says is, don't keep us out, let us in. And we've been there, we've gotten in, right? And that's the history of the 20th century, is including more and more groups within society. The problem is when you get there, that the society is not operating in a way that actually produces greater equality, true equality. And I think one of the reasons for that is the way that our institutions define power relationships, not associated with traditional identity categories, but rather with these social roles, what's assigned value in the creation and construction of these social roles.
Thank you for being here. I really enjoyed this lecture. And I was just wondering if you could talk a little bit about the way the state punishes people and how that can be done without breaking down resilience.
Without what?
Breaking down resilience.
I'm sorry, I still missed the list.
How the state can punish people without breaking down resilience.
Oh, without breaking down resilience. Well, the state does not provide resilience in the context of its criminal justice in there, in quotes, justice system. And in fact, that would, in reforming the criminal justice system, what should be the question is how that it should be used to promote resilience. I mean, how is it that we can use necessary incarceration, and that's a whole question, what actually constitutes necessary incarceration, but how that could be used, in fact, to promote resilience. And some people are concerned with that in fashioning projects for after prisoners are released, how do we, in fact, integrate them back into the community? Or thinking about substituting incarceration with something called community justice, a kind of notion of changing, not putting people in prison all the time. I have a lot of international visitors, and I had a group from Korea come, and we did this session looking at comparative law in regard to children. And it was really interesting because their response to the way that we organize our juvenile justice system was eye-opening. They said, you put 13, 14, 15-year-olds in jail? We don't do that in our society. What we do is that we bring help into the family to work to leave the child in the family whenever possible, and not to institutionalize them. And actually, this would be providing them and the family with resilience so that that problem could be addressed. So it's rethinking along those lines. I don't know if that helps.
Can I ask you to talk a little more about why the state, I mean, this may be an obvious thing to say, but is why, as opposed to other institutions that might be able to promote resilience as well? I mean, I'm thinking about, at least in the past, religious institutions.
Mm-hmm.
What is it about the state that's necessary to your analysis? Is it because of the turn toward the neoliberal in the late 20th and early 21st centuries, or in other words, is it historically contingent, or is it more because of the nature of law and its relation to social regulation?
Yeah, and the legitimate exercise of power.
Right.
And religion, at least from my secular perspective, is still voluntary. I mean, we're talking about charity rather than talking about, redistribution. The state is the only institution to which we all must belong. And I think about the state complex, and again, I'll go into that a little more in the next lecture. But I do see the state sharing with the institutions that it creates through law, right, and policy, sharing responsibility. And I think that but it's a shared responsibility. It's not the privatization of state responsibility, the fostering everything off into these so-called private institutions, which are really not private, but actually also public.
If I could follow up on that, and actually going back 2 questions then, I don't know if it was today or yesterday, there was an article in the New York Times about the privatization of incarceration of detention centers for immigrants and refugees.
Right.
Can you, I mean, it's, I guess I'm not sure what my question is. It's almost like an empirical case. It's a phenomenon.
Right.
And I really enjoyed your talk, and I'd like you to sort of theorize about that, think out loud about that kind of phenomenon, because it is dealing with a vulnerable population, not part of the but it's not part of the citizenry. You said that the state is, the institution to which we all belong, so this group does not belong.
Well, when they're here, they actually do belong. I mean, they actually do belong because they're subject to its rules. So in that context,
Right.
they belong.
But again, I wanted to put that out there as an empirical case where I can respond to it.
Well, again, this was the first lecture where I actually talked quite a bit about the division of the world up into public and private. And part of that is related to the fact that at the time our Constitution is enacted, we have an 18th century perception of political theory, which in fact did divide the world up into public and private. So privatization is not only a new thing with things like incarceration and immigration, but privatization goes back a long way. And I spoke a lot about the privatization of the family, the privatization of responsibility for dependency and vulnerability and so forth and so on. It occurs because we consider the family outside of state responsibility. So that's historic. It exists historically, and it is a scandal when you see what's going on actually with not only immigration, but with incarceration in general. It is a private profit-making industry. And the state can say they don't have responsibility. What I would argue is yes, you do, because that's not a private industry. That's in fact the referral of a public responsibility to a privately created entity, and it deserves supervision, and that it should be supervised. Yeah.
I work with a lot of very optimistic early childhood educator policy types who actually think that we're on the verge of reintroducing the idea of childcare based on the first 3 years, right? So the potential that in the United States we can return to a policy discussion around universal provision of childcare. And I'm thinking about this in terms of the history of our perception about this, which is often that either we imagine that you have a kind of public provision based on need, right, the neediest, but not necessarily on universal working position of women, except with a couple of exceptions. And I'm wondering, are there places that, I'm just so struck with the final destruction of the need-based piece, which was the Personal Welfare Responsibility Act of 1986, or 96, I'm sorry, 93,
96.
I'm a historian, but I remember that. So I'm wondering where that fits into this, or if this is something you're addressing, or you've heard some of the discussion.
Well, the TANF, the welfare reform in 1996, was consistent with the goal of neoliberalism to dismantle what was actually accomplished in the New Deal, what was accomplished under this idea of social justice, which takes its legislative form in many of the New Deal and Great Society and so on, Johnson's programs also. So the whole purpose of neoliberalism is to dismantle that. And they do so by this radical notion of individualism, which is the individual responsibility. They removed, one of the things that Roosevelt said was that this protection against the harshness of the market should create protection as a right. Now, one of the things that the welfare reform of 1996 does is to end the notion of entitlement. It ended 60 years of saying that if there is a poor family with a dependent child, that family has a right to economic assistance. It ended that, and it was a big deal, and a Democratic president did it, which is kind of interesting. but it was a major victory. They've been fighting to dismantle the rest of it. Social Security is another trouble. Of course, Obama snuck in Obamacare, which is you as a social justice program. But the Supreme Court managed to take away the universality of that. So there you have another problem. But yeah, I mean, you can look at all of these battles that we're having now and have had in recent history through this notion of, the debate to undo this concept, this collective concept of social justice and to substitute for an individualized sense of social justice, if you can call it social.
I want to circle back to Brent's original question for a second. Sociologists, when I think about what you're talking about, it's generally the case that when we look at roles in institutions, we also acknowledge that the way those roles are understood and defined are based on who inhabits those roles because of hierarchies of difference that are embedded in enduring social structures, right? So that caregivers, at least in this society, paid caregivers tend to be poorer people of color, often gendered as female. And you seem to be making an analytical move to separate those two. Contrary to what I think a dominant sociology would say as they're being necessarily mutually informed.
I think historically they're informed, but I think that, and again, this is really an important point, and I'm not a sociologist, but I'm a legal theorist, and when I look at things, realize that law, in fact, affects change. And things are not the same as they were 50, 60, 70 years ago, not even the same as they were 25 years ago. So what my realization came from was working through the notion that somehow or another caretaking was a gender discrimination, a problem of gender discrimination. And I realized, after struggling with this for a number of years, that the problem was not the gender of the caretaker. The problem is that society does not value caretaking. It doesn't matter who does it. This is a problem that transcends gender. It's a problem with social values and money. It's this problem of the division of things up into public and private. Now that division originated when there were strong divisions in gender expectations and gender roles. But that's no longer true. In fact, you can look at the history of, in legal terms, the structure of these institutions over the course of the latter part of the 20th century as saying that we effectively achieved equality. We now have gender-neutral rules. But the problem is that the gender-neutral rules don't take care of the problem, which is the caretaking dilemma, which has historic gender implications, but really transcends those categories. So I think it's important, as I said, I'm asking you to think about it differently than you do according to those categories, to look at the problems as they exist today and disassociate them to some extent from their history so that we can actually look at how these problems transcend traditional identities. They cannot be handled with a policy of anti-discrimination. It won't get us where we need to go. Discrimination is a weaker tool. And we really have to talk about social transformation, institutional transformation.
I would like your thoughts about the status of children, the vulnerable children. This is one instance where there are social institutions that are aimed at promoting some degree of resilience, right? Child welfare and child protective systems, they've been, they're very problematic and they've been weakened, but those social institutions do exist. But they also treat children as less than autonomous subjects. So I'm curious about your thoughts about kind of how those tensions play out.
Yeah, well, there's a couple of things. One, again, I'm asking you to think about things differently. So I don't think about vulnerable children, or even children as vulnerable or uniquely vulnerable. But I think about it as the vulnerable subject in childhood. okay? It's universal. All of us are the vulnerable person, the vulnerable subject in childhood. And what happens in that childhood affects us as we age. This is the notion of sequential resilience building, for example. So I would resist classifying some children as uniquely vulnerable. I think we want to think about childhood as a vulnerable subject in childhood as a time where we have to pay particular attention to the state investment in resilience building. So we can say that childhood is, in fact, for all of us, a state at which building resilience is extremely important. It's going to affect the rest of our lives. So maybe we need special attention, but not just to some families, because here comes in the question of stigma, right? All families. We have to talk about investment in families. We have to talk about education broadly and not make it a means-based kind of approach. In that lies stigma, and eventually, failure due to budget deficits and other sorts of things.
Okay, well, I hope you'll join us at the third lecture, which is on March 24th, and I